Excellent. I think the recording is. Well, good afternoon, everyone. My name is Jahangir Saidov. I'm Professor of Commercial Law and Director of the Professional Law Institute at the Dixon Poon School of Law, King's College, London. Thank you very much for joining us today, and a very warm welcome to you all to this first event in the Future of Legal Practice lecture series in 2022. Just a few words about the series first. This series was launched by the Professional Law Institute in 2019, and since then many interesting lectures and talks have been given as part of the series. The series is forward-looking in its outlook and explores some of the most topical themes and challenges that the legal profession and the legal world more generally faces in the fast changing world. Now, today's talk could not be aligned any better with the spirit of the series. So we're focusing on technology, generally speaking, today. Now, we all know that the new technologies have been developing at breathtaking pace in recent decades. Technology has been central to our daily lives, our professional activities, businesses, and society as a whole. New technologies pose some fascinating and unique legal challenges as the law tries to respond to them, as the law tries to accommodate technological developments and revisit or rethink traditional legal concepts. The Law Commission of England and Wales has been doing some important work in this direction, and this is what our talk today is about. So today's lecture will discuss the Law Commission's recent work on emerging technologies, in particular the advice to government on smart contracts and the legal problems to which digital assets give rise. We will learn about the implications of the increased commercial use of emerging technologies for the law and the Law Commission's proposed responses. Now, it's with great pleasure that I would like to introduce our speaker, Professor Sarah Green. Sarah was appointed as Law Commissioner for Commercial and Common Law on the 1st of January 2020. She was previously Professor of Private Law at the University of Bristol. Prior to that, Sarah was Professor of the Law of Obligations at the University of Oxford, and having been a lecturer at the University of Birmingham from 2001 and 2010, and I had the pleasure of being Sarah's colleague at the University of Birmingham. Now, before embarking on her academic career, Sarah was a software consultant at Accenture. Sarah has written books and articles on a variety of issues that included virtual currencies, blockchain issues surrounding intermediated securities, smart contracts, sale of goods law as applicable to digitized assets, negligence, and wage theft. Now, a few housekeeping matters. Please do bear in mind that the session is being recorded. The presentation itself will last for about 40 to 45 minutes. And after that, we will open the session to questions and discussion. I would kindly ask you to keep your microphones muted during the presentation to prevent any sound interference. So I think that's probably enough from me for now. So Sarah, over to you. Welcome.
Hey, thank you very much, Jahangir. Thank you very much for inviting me to come and talk at this series on such a fascinating topic. And thank you very much, everybody, for listening. As Jahangir has mentioned, I intend to talk about the Law Commission work and the issues that we've encountered during that work for a bit. And then hopefully there will be questions or comments arising from that, which I'm always very happy to take. I'm going to talk a bit. I do have some slides that I'll put on screen in a minute. I'm going to talk a bit about the way that the Law Commission works, because it's very important, I think, for people to understand that we're a very consultative body. So occasions like this are actually fantastically helpful to us and to me personally, because it's really very important for us to get a good sense of what other people think of our ideas. We certainly don't work in a vacuum. So basically, all of that is to say, please do not be shy. If there is something that you want to say, a question that you want to ask, or a comment that you want to make, or you think something that I've said is bizarre, or not going to work, or even if you do think it's really good, please do say so, because this is, in many ways, these sorts of occasions are really, really for me to test some ideas that we've been thinking about internally. Now, that is always the case with Law Commission work, but it is particularly the case in the technology space, because a lot of what we're doing, and as you will hear in a minute when I start talking about smart contracts specifically, a lot of what we're doing is having to speculate. So looking at smart contracts and having to speculate to some extent, as lawyers we always I suppose do, particularly for instance when we're drafting statutes, we have to imagine what problems and what issues are going to arise in the future. Now, of course, to some extent we work on the basis of things that have already arisen. But what we've really found with these projects that I'm going to talk about today is, because these technologies are certainly already being used, and I think being used to a greater extent than a lot of people think they are still in their relative infancy. And so a lot of these points that I'm going to dwell on for a while are things that have yet to be fully tested. So that's really my introductory spiel. What I'm going to do now is I am going to share my screen. So as I said, I have a few slides. If questions or comments occur to you, I think it's right. Lois might correct me if I'm wrong, but I think you can put them in the chat, or you can put your hand up. If you want to write them as we're going along so that you don't forget, then by all means do put them in the chat, and I can get to them probably at the end, given the way it works out. But as I said, please don't be shy about that. Hopefully we can have a discussion, a useful discussion on that. Right, so Chikonge, can you give me a thumbs up if everyone can see my screen?
Yes.
Fantastic. Okay. Thank you. So I've already been introduced, so I don't have to bother with that. Thank you, Chikonge. But what I said that I would do first, which I think is really important, is just to talk a little bit about the Law Commission and how it works. I don't think that I didn't really realise exactly how the Law Commission worked before I got the job. I did have an idea, but I certainly didn't know everything about it. So I think it's worth me saying a little bit about that at the beginning. And then I'm going to talk about the Smart Contracts project. So we published an advice to government in November 2021, so very recently. And I want to talk about our key findings on that and where we go next, and our future work, because we have also another, certainly at the moment, 2 ongoing projects which fit with the emerging technology theme. And they are concerned with electronic trade documents. And then there's a broader project on digital assets. Now, I'm going to talk about all of these in a bit more detail this afternoon. But what's really important, I think, is to make the point that those 3 projects do, of course, interact with one another in really important ways. And it would have been quite difficult to do work on electronic trade documents, so digitized versions of paper documents. For instance, a bill of lading. I'm sure you're all very familiar with that concept. And digital assets more generally. And as you'll see, that is going to cover virtual currencies, non-fungible tokens, any sort of token really, particularly at the moment on a distributed ledger. It's very difficult to talk about the legal implications of those things without talking about smart contracts and their legal implications, because of course that's the way that a lot of these assets are dealt with and transferred, for instance. So I think it's really good. I feel very, very fortunate to have this job at this time in our lives, really, because the technology that is currently in development means that all these questions coming to the fore at once. And I think it's just fascinating to be able to deal with them all. They're really important questions. I don't think there's any doubt about that. And the law does need to keep up with them. And it's just very, very nice for me, because these are issues that I've been thinking about for a very long time. As I said, I feel very fortunate to be doing all of these things together. So there are just a few points I want to make about the Law Commission. What's really important to realise is that we are an independent body. So I've already mentioned our highly consultative nature. It's not as if I, as Law Commissioner, can impose my will on the law in this area, or indeed any area. So basically, I oversee consultative research projects. And what we do is we are commissioned by government. So we have our funding from government. The way that works is that government commissions us to look at a particular area and then hands it over completely to us. So once it's at the Law Commission, it is not a politicised process in any way. I mean, in fact, in some cases, government will give us a project specifically because they want to be able to have a finished set of recommendations, for instance, that are not coloured by any political emphasis, or haven't been really affected by any sort of political formation, because of course that's very, very valuable for government to be able to do that. I've seen us referred to sometimes in the press usually as a government department, and we are absolutely not that. You can see from that slide we are an arm's length body. So we operate independent from government. And consultation, I've made this point several times, but it definitely bears repeating. We are in listening mode until the very end of our projects, when we're putting our final proposals together. We come up with we consult about the proposals in the first place. Then we come up with proposals, we consult on those again. We're very reflective. We go back, we look at what we've suggested. And if stakeholders have expressed reservations, then we will change our proposals, because our objective is very much to make the law as modern, fair and accessible as possible. So we listen to stakeholders from across the board, whether they are users of a given technology, whether they're legal advisors, whether they're the people who develop the technology, whether they're their insurers. You know, it really doesn't matter. If somebody has an interest or a view, then we want to know about it. Of course, in this area, there's an awful lot to be said. Okay, so I will start with smart contracts. Really, there's no obvious order, I think, to talk about these projects, but chronologically, we finished this one first. So as I said before, we've produced a publication called An Advice to Government. Now, that in itself, I think, is quite interesting with smart contracts. As you can see from this slide, we were asked by the Ministry of Justice, essentially, to decide, or to look at, I should say, to evaluate whether the law of England and Wales was appropriate and able to accommodate smart legal contracts. And as I said, our objective is to make sure that the law is modern, fair and accessible. And the Ministry of Justice wanted to make sure that if parties wanted to use smart contracts, that they could do so using the law of England and Wales. And it's obvious why they would want that to be the case. So we went away and we evaluated, as I said, talking to stakeholders, talking to people who already use smart contracts, to their legal advisors, to the technologists who develop the platforms on which these things are built. We talked to all of them with a view to ascertaining what, if anything, had to change about the law of England and Wales in order to make sure that parties' legitimate expectations, of course, that's a phrase that we encounter all the time in the law of contracts and indeed in commercial law. We wanted to make sure that those legitimate expectations could be met by the law of England and Wales. And so we wanted to identify any areas in which that couldn't happen at the moment, and then suggest, the idea was that we would go on and suggest reforms which would make that be the case, even if it wasn't already. So Many of you will have seen, I imagine, if not been involved with, I just had a little scan down the participants list, the UKJT, so that's the UK Jurisdiction Task Force legal statement, which was produced in November 2019. And that was an analysis of smart contract, of emerging technology. I think the easiest way to put it, it was emerging technology at the time. Those things really that are built on distributed ledger technology, so crypto assets, smart contracts. And it was an analysis of how the current law fitted with that emerging technology. It was an authoritative statement, very well done, and very well received across the globe. So it was used as a really important reference point for lots of jurisdictions. It was then our job at the Law Commission to build on that, because essentially, for present purposes for this afternoon, the conclusion of the legal statement with which we were concerned is that the law of England and Wales can accommodate smart contracts. There's nothing to say that it can't get to a point where it can accommodate smart contracts. And so we really needed to work out the detail. And if necessary, as I've said, change the law to make sure that it could. So that's where we were in terms of chronology. Now, let me just remind myself. I'm going to come back to these. Yeah, I'm just going to skip forward to this slide though, because I think what's important to say earlier on is that actually we do several types of different publication at the Law Commission, and conveniently, I think with the projects that I'm going to talk to you about today, you'll see an example of each one of them. So I think the one that probably people are most familiar with is that we will publish a final report on a particular area which has proposals for government for changes in the law, so recommendations for changes in the law. And that is sometimes accompanied, as you will see later, by a draft bill. So we have our own in-house parliamentary counsel, who are these amazingly talented individuals who write statutes, and it's immensely difficult exercise if you ask me. So what we do is we go to our parliamentary council, we say this is what we want the statute to do, and they write it, and it becomes a draft bill which we then submit to the government. And so sometimes we do that, and we've done that with electronic trade documents. I'm going to talk about that in a while. We also do consultation papers, which are prior to that. So we consult, we make provisional proposals, which we then put out for consultation. We work on those, and they become a final report of the type that I've just mentioned. And we're doing that at the moment with digital assets, as you will see in a while as well. But the point I wanted to make about smart contracts and the work on that for the moment is really the second two bullet points on this slide. Is that turned out to be what we call an advice to government, which is another of the publications that we do. And that's because we realised throughout this project that actually we didn't need, or at least we felt we didn't need, to make any statutory reforms. We didn't need to recommend any dramatic legal changes, or in fact, I mean, I will go into detail in a minute, but really any legal changes at all, because, and this was, I have to say, personally a surprise to me. I didn't expect it to have quite this result, although, of course, in a way, I'm quite pleased that it did, because this is the easiest outcome, is that actually with a bit of common law incremental modification, the law of England and Wales can already deal with smart contracts. And that was a revelation, and I think a really interesting revelation. So I'm just going to talk about that now. I'll go back. Okay, so I just sort of didn't want it to be like a whodunit novel, really. I wanted to make it very clear at the outset that that's where we got to with smart contracts, which, as I said, I think is a really good result. But of course, we couldn't just, as the Law Commission, say, right, actually, go away and deal with it in courts and the common law can do it all. We did do the work as well. So we went through all of the salient elements of contract law and tested our conclusions, and then set out exactly why we think that those reforms are not necessary. But first we had to start with, and this was remarkably difficult, this was another surprise to me. So I thought somewhat naively that this would be the easiest part of the project. Checking out, introductory paragraphs, here we go, these are our parameters. What is a smart legal contract? It turned out to be phenomenally difficult, largely because every single, and this is not an exaggeration, every single stakeholder we spoke to, and I've already given you the full, account of who they are, different people, coming at it from different perspectives, having different interests, but they all had a different definition of what they thought a smart contract was. Now, admittedly, in many cases, they were just sort of on a spectrum. There were shades of difference rather than dramatic differences. But the point remains that if you asked any of those stakeholders, right, tell us what you think a smart legal contract is, there was no consensus. So eventually, actually, that turned out to be, we sort of had a few days of panic of, how on earth are we going to set the parameters of this project? We can't even say what a smart legal contract is. But actually, it turned out to be a virtue, I think, in terms of the analysis, because we realised that actually it doesn't really matter. And it might have been, I suppose, in the end, that it doesn't really matter because of what we'd said about how the law needs to adapt, which is incrementally and through the common law. And so we didn't really need a sort of discrete, bright line definition in the way that we might have done if we were going to try and put a draft bill together, for instance, on this. So what I think came out of this, which was really important, is that there is a spectrum of what amounts to a smart legal contract. And the technologists who work with the sort of nuts and bolts of smart legal contracts thought this as much as the lawyers advising the parties who want to use them. And really, what's very important about this, now clearly, because we are the Law Commission and a smart contract as a term is something that's incredibly broad, and non-lawyers use it all the time to refer to things that we as lawyers wouldn't think of as contracts. So that's why our term for it has the word legal in there as well, because a smart contract, as far as a technologist is concerned, can be simply an algorithm that runs in an automated way. Whereas, of course, as lawyers, we are only interested in the subset of those which are legally binding because they have the ingredients of a contract that we recognize. Right, so smart legal contracts. But even then, even within that subset, there is this spectrum still of different types. Now, even though it is a spectrum, we did actually highlight, as you will see from that slide, we did actually highlight 3 sort of broad types. And that was really just simply not to provide any, as I said, absolute bright line distinctions, but just to give some indication of the way that parties are using smart contracts. So the first of those is one which is mostly a natural language contract of the sort that we all see or are used to seeing, but where some of the performance is automated and done by code. There's other contracts which are just further along the spectrum, which have some terms coded, but they also have some natural language terms. And of course, there's automated performance involved in that. And then finally, and I think these are the sorts of smart contract which are less prevalent at the moment, but that also present the biggest problems for law or the current rules that we have at the moment. And those are contracts which are constructed entirely in code. Usually, obviously, you might imagine, by 2 parties who are entirely code literate, and actually often are doing this because they don't actually want, or at least they don't think in the first place that they want any legal intervention. They want code to be law, which a phrase that you might have seen, like code is law. And that's all very well, of course, until something goes wrong and they don't agree with the resolution that the code might offer them. So that's the sort of thing that we're talking about. So we then looked at the life cycle, if you like, of a smart legal contract, and this just has an analogy with a conventional standard contract. But these are the different issues that we looked at individually. Interpretation was the one that I'd spent a lot of time thinking about before. I mean, that's thorny enough when we're talking about conventional contracts. So it was never going to be straightforward with smart contracts. And actually, just as a little spoiler alert, interpretation was, once we did our advice, it was the area in which probably the greatest incremental change needs to occur. But I will talk about those individually. So why did we think originally that agreement, in terms of contractual agreements, might pose problems for the current law as we know it? There is, you might say, a prima facie question about whether, as you can see, if you don't have any natural language communications, if you do this entirely on code, can that amount to an agreement? And there was this other question, and I've already alluded to this really, about intention to create legal relations, in that sometimes parties might engage in a smart contract for the very reason that they don't want a third party body of any type to be involved. Obviously, with distributed ledger technology, you can engage in financial transactions that don't require a third party. That's the whole point for a lot of people of cryptocurrencies. You don't need a bank. You can do the whole thing on a peer-to-peer basis. And if you do that, and if you don't want courts to be involved should things go wrong, how does that affect your ability as a contracting party then to show your intention or otherwise to create legal relations? So those were the two areas around formation that we encountered. But actually, as you will see, or might have seen already in the advice to government, there is no legal reason why those things cannot be shown in an analogous way to the way that they are with conventional contracts. So, of course, there are various ways in which contracting parties can show their intention and their offer and their acceptance, and they've always evolved over time. We know that. If you think about the case law that started to come into being when computers started to be used and email started to be used, and even if you go back before that, when you had faxes, there were various different ways that parties could communicate their agreement. And contract law, it's malleable. It developed incrementally to accommodate these changes, and all sorts of other changes too, like bank money, as opposed to I'll come on to that later on with the digital assets. So of course there are in writing requirements for certain contracts, and that arose as a question as well, although again that was a surprisingly easy one to answer, in the sense that even computer code, even machine code, source code I should say, sorry. So source code is the bit that humans can read and interact with, and then machine code is the bit that the computer reads. So you compile source code into machine code, but the source code bit, the bit that you see on the screen as a coder, is fine for the purposes of the Interpretation Act for in writing, because it is words in visible form. Signature requirements, and the Law Commission produced a report in 2019. And again, this was a sort of advice authoritative statement. We don't need to change the law. It is already the case that electronic signatures can, as a general principle, work as a perfectly legitimate means of authenticating a document. There are certain particular formalities of some documents where that won't work. But generally, where what is required is a wet signature, most of the time you can use an electronic signature to do that. And of course, that's really important, particularly important with smart contracts, because they work in an automated way without human intervention, or certainly with limited human intervention. And so it's very important that you're able to use an electronic signature for that. Now, this is, I think, as I said at the start, the most difficult aspect of smart contracts for the forensic process. Not only because interpretation is, as I've said, fantastically difficult anyway, even for conventional contracts, given the sort of richness of human language and the difficulties and ambiguities that arise from it. And of course, we as humans all speak in different languages anyway. So it's, you know, it's not unusual for a court to be presented with a contract in a language that the judges don't themselves speak. Right. So there is that. But actually, the problem is exacerbated with smart contracts because it's not just a case of the judges who are being asked to interpret a particular term perhaps not being code literate. And at the moment, I think it's true to say that most of them are not at the moment. And so we have that to deal with. The other point is, and this is why it's particularly difficult with smart contracts. I mean, we're all familiar with the objective test of contractual interpretation. You know, what would the terms mean? You know, it's certainly not subjective. It's not about what the parties say that they meant. It's about what their manifest agreement would mean to a reasonable observer. The problem with just applying that without changing it to the smart contract context is that that's a reasonable question to ask when what you're trying to get to is what a reasonable contracting party would have thought that agreement meant. But that's no good when that agreement has to talk to a computer, because there is no such thing as a reasonable computer. Computers do not interpret text, they execute it. And if you tell them the wrong thing, they will always do the wrong thing. If you tell them the right thing, they will do the right thing. So in a sense, there is an asymmetry there, because you have humans who both might think they are telling a computer to do a particular thing. And of course, they might have their own subjective views on what they're telling that computer for a start. But then there is that code. And I mean, I used to be a coder. I've worked with coders. There are, you know, some incredibly brilliant computer coders who will tell you that they could write a piece of code, particularly if it's very complex, and think that it's going to get a computer to do a particular thing, and it actually doesn't, at least not before it's tested. So basically, there is another layer of difficulty in interpreting coded contracts, because you have that asymmetry. You can't just look at a piece of code and say, well, this is what it means to humans. This is a reasonable human interpretation. Therefore, this is what it means, because those humans wrote that code for a computer, or at least the coded it. So this was really difficult. I could talk to you about this for hours. Don't worry, I won't. But this was, I think, the most interesting part of the project and the most difficult. But essentially, as you can see on the final point there, really we thought that it's the easiest way to deal with it is by using a reasonable coder test. And actually, that's not a huge move on from what happens with conventional contract law, because, of course, you imbue the reasonable person looking at that agreement with knowledge of the circumstances of the case. And any technical language, because of course we see this all the time in other technical contracts. So what we suggested here was that you would ask, would a reasonable coder think that this interpretation is the, you know, aligns with what the parties had in mind. It's not as straightforward as, say, presenting an English court or an English judge with, say, a contract written in Japanese, and that judge doesn't speak Japanese, because what happens there is the foreign language expert would tell the judge or judges what those words mean. And it is still for the court, of course, to interpret, to do the legal bit, to do the interpretation of what the contract means. So they're told what the words mean, but they have to interpret what the contract means. And that's, again, slightly harder with computer code, because, I mean, that it is written, source code is written in language. And so, say, if I, as an English speaker, looked at code that was written by an English-speaking coder, I would understand what the words mean, but that doesn't necessarily mean that I would understand what it's telling the computer to do. So there is this extra layer of difficulty with smart contracts. But we think that applying a reasonable coder test can get us over the worst of those difficulties. Remedies was another issue that we thought needed looking at, and that's a really interesting one. I think what's going to happen with smart contracts is that certain contractual remedies will have a sort of renaissance and be used a lot more than they currently are. Rectification, actually, I think is going to be a lot more important with smart contracts. Now, technical rectification, and rectification is obviously used where you have a written manifest agreement that doesn't accord with what the party's actual agreement was, and the court then obviously has the power to rectify it, to make it agree. And you technically, so this might happen in cases where parties have thought they were telling, imagined they were telling a computer to do a particular thing, but actually the code was wrong, so do it. They both agree that was what they wanted it to do. The difficulty with rectification as a term of art as it currently stands is that if we're talking about code written on a distributed ledger, it's actually immutable in many instances. You can't actually change it as a matter of physical fact. I'm not sure that that really matters too much, because you can have effective rectification in that you could rerun, or rather run, a smart contract that changed the effects of the first. So although you're not actually rectifying the same kind of electronic piece of paper, for want of a better analogy, you are achieving the same end result. Obviously, that's most important for sort of ongoing relational contracts. Where you have one that's already executed, there's not a huge amount of point in doing that, but you can still achieve the practical effects of rescission. You could do that on the blockchain. You could order or the court could order an equal and opposite second transaction, or damages could just be given in the usual way, sort of off the chain. That's what determines perhaps if that's what the parties make. Right. Unilateral mistake. So mistake, again, another thorny concept in contract law, particularly tricky, I think, with smart contracts, where you have an automated contract which is ultimately concluded. So two parties write software, which is, if you encounter X price, buy Y, and so on and so forth. What you've got then, of course, is essentially two computers interacting. And what happens, as it did in the Singapore Court of Appeal case that you see there in Coin, where that doesn't operate in a way that the parties, at least ex post facto, said that they intended. But actually, we realised that although this sounds sort of very, very difficult, that the standard tests for mistake, and particularly unilateral mistake, there is no reason, obviously it's quite a high bar anyway, there is no reason why that cannot be applied to smart contracts. What we realised is that it's actually not the law that needs to change, but the sort of physical appearance of the way in which the law is applied. And that actually, if you look within smart contracts and the way that they operate, the principle of unilateral mistake is absolutely sound, and it still does what we want it to do, which is, well, we all know what unilateral mistake wants to do, but the parties still have the same expectations. They still have the same ability to avoid these risks eventuating. They just conduct their agreements in a different way, which is through code, through computer programs. But there is no reason why the content of those programs and the intention behind those programs and the way in which they are put together and discussed between the parties cannot be analysed in exactly the same way as a conventional agreement. That's essentially what the Singapore Court of Appeal did in Coin. And when we looked at that in the context of English and Welsh law, we realised that exactly the same was true. So what was really interesting about this project, I've already said I was quite surprised by the outcome, is not that the legal principles need to change. You know, that legal toolkit is absolutely well suited to smart contracts. It's going to be a question of courts, of parties, of judges, of legal advisors, just getting used to that application looking a bit different and looking for different things, different hooks, if you like, on which to hang those means of getting to the answers that we're used to seeing. I've said all that, and I am aware of time. So I've probably got about 10 more minutes. I do want to talk about the other two projects, albeit more briefly. Those are just two things that we are going to look at. I've talked about particular types of contracts, so deeds. We're also looking, we have a separate project on deeds at the Law Commission, and we also have a project starting in the middle of next year on complex issues in private international law, because, of course, when we're talking about smart legal contracts in private international law, the question arises in terms of property, where those things are cited for the lex citus. And of course, it's not at all obvious sometimes where those assets are, and maybe not even an authentic question. So thankfully, I'm very excited about that project. We're going to be looking at that later this year. But for now, I am going to run through electronic trade documents and digital assets and just the point behind those. And at any point, Jakongi, when you want me to stop, please. Basically, electronic trade documents is a project that's nearly finished. We have a draft bill going through the motions now, and we're very hopeful. The most we can do is put the ball in government's court, but we're very hopeful that this will become law. Essentially, what we were asked to do here, and it surprises a lot of non-lawyers, particularly that this can't already happen, is to allow, quite simply, trade documents to be used in electronic form and automatically therefore have exactly the same effect as their paper counterparts. Currently, they don't do this. You can't have an electronic trade document at the moment that functions as a document of title in the same way that a paper document can, because you cannot, as a matter of common law, possess an intangible, and electronic trade documents are deemed to be intangible. So basically what this project aims to do is to get rid of that blocker in the law and say, look, just because something is intangible or is perceived to be intangible, I don't personally believe that they are, but that's irrelevant, is that actually tangibility is a bit of a red herring. It's something that has always been associated with possessibility, and that's no surprise because historically everything we've wanted to possess has been tangible. You know, and it was all tractors and factory machinery and bags of gold and horses and cattle. Of course, those are tangible things, and it's obvious then that you can possess them. But with distributed ledger technology particularly, there now exist digital things that actually exhibit the same legally salient characteristics as historically tangible things. We can solve the double spend problem now in an electronic way, in a way that we couldn't historically. So if you had something that was electronic, like a Word document, I could pass that on to as many parties as I wanted to. And of course, if what you're talking about is a commercially significant document of title or means of payment, that's no good because you can double spend it. But now that it is possible to have these digital things, and I use that word deliberately because it covers a broad spectrum of different sorts of assets. Now that we can do that, there doesn't seem to be any reason for the law to focus on tangibility when actually it's those other physical characteristics that are important for possessibility. So that's what we did with electronic trade documents. We put a bill together. It's very short, basically says if a document exhibits certain characteristics, the fact that it's electronic does not stop it being controllable, does not stop it therefore being possessed, does not stop it therefore functioning exactly as a paper document does. So i.e. it can, for instance, be a document of title, it can be held, it can be transferred. And this fits with digital assets. So the digital assets project is basically works on exactly the same basis, but it's broader. So digital assets is the same question. How should the law change and develop to accommodate these assets which we're not used to seeing, but which are, as we all know, incredibly important and already represent a huge amount of, well, I was going to say personal wealth, but it's more than personal wealth. There's a huge amount of general wealth that is focused now in digital assets. And so it's really, really important that the law of England and Wales knows how to treat them and can say with certainty, if you have a digital asset and if your digital asset is this, then this is the legal response to, well, whatever, to transfer, to conversion, to theft. We think it's really important. And they're all based on this idea that actually we need to forget about tangibility because that is no longer the touchstone of things that can be possessed. We certainly don't want to make everything possessible. So we're not saying that all intangibles like debts or whatever, I mean, debt's the obvious example, like genuine things in action. We're not saying that they should all be possessible. What we're saying is if something has certain characteristics, then it should be. Those characteristics, basically, it has an independent existence. So it exists regardless of whether anyone lays a claim to it, i.e. not a debt. And it exists regardless of whether a legal system recognises it. Again, not a debt, but a database ticks both of those boxes, at least potentially. A document or a token on a distributed ledger could certainly tick both of those boxes. It is external to persons, it is external to the legal system, and therefore it should be possessible in the way that tangible assets, like a horse, obviously that exists whether a legal system recognises it or whether anyone lays claim to it, it's still there in the world, and so are quite a few digital assets. So we're considering changing the age-old dichotomy, things in action, things in possession, the famous quote that there is no tertium quid, there is no third category, there is no third way. Well, maybe it's time for there to be a third way. We did for a while think about whether we should take those digital assets with the characteristics I've just mentioned and say, well, actually, they should go in the things, the things in possession category, which would give them all the legal implications that really we want them to have, because it would make them analogous with bags of gold and horses. But then we thought, actually, maybe that's not the easiest way to do it, because there's an awful lot of historical baggage that goes with that category. And perhaps it isn't all applicable to digital assets. You know, they look very much like, well, actually, they look nothing like, but they function very like conventional assets. And yet maybe we should be a bit more sensitive to some of the changes. So we think current thinking is that actually a third category of personal property might actually be the way forward, that recognises these things can be possessed, but actually is sensitive to the slight differences that there might be between conventional things in possession and digital assets. We're doing this in the way that I've just explained, you know, our independent consultative way. We are in listening mode. We are also working with working alongside, I should say, international bodies. So obviously all jurisdictions are grappling with the same issues at the moment. We're working with or alongside, we sit as observers. I think that's the best way of putting it. So we sit as observers on the bodies of the, say, ULC, of UNIDROIT. We all contribute to what the others are thinking, and we are very cognizant of what is being done elsewhere, because of course the global nature of these transactions means that there's absolutely no point in doing it completely unilaterally, but we all are also sensitive to the fact that our own jurisdictions will have particular requirements in terms of how our current law should be tailored. But the bottom line is, for both of these projects, so digital assets is going to take the form of a consultation paper halfway through this year. If any of you do have any thoughts on any of this, please do respond to that consultation paper. We haven't yet decided in terms of digital assets what's the best way to go about this legal change. You know, does it require legislative intervention? Don't know about that yet. Again, views welcome. But the basic point is, it's decoupling possessibility from tangibility, because we think that is a necessary correlation, and it's understandable why it's happened over the years, but it is no longer useful, and it is no longer an authentic means, we don't think, of distinguishing between those things that can be possessed and those things that can't. That would seem like, I've got so much more to say, but I have much more time, and I am very interested in your thoughts and any questions you might have. So I'm going to leave it there, and I'm back on screen. Can you see me yet?
Yes, yes. Thank you very much indeed. And there have been quite a few comments there and questions in the chat. So perhaps we should start with those.
Okay.
I might just group them. So I think there are two sort of comments questions in relation to a reasonable coda test that you've proposed. So I believe these are our LLM students, if I'm not mistaken, asking those questions. So one is asking, how do you pin down what a reasonable coda is? I agree this is the right approach, but it's not easy to use it as a reference point for the reasons you have cited. And then we have another related comment saying, I expect that expert testimony will become important in interpreting what a reasonable coda is. So would you have any comments on those?
Yeah, absolutely. I mean, they're very good points. And I think what we had in mind was that actually either parties or courts would actually engage a coder as an expert witness. So you would actually have a coder in court, and then the questions about what a reasonable interpretation of the given code could be direct to the coder. Because I agree that if you're talking about if you have non-code literate judges trying to decide what a reasonable coder would do, that's going to be incredibly difficult. And of course, that's the reason. And if we sort of think across to tort and the tort of negligence, if anyone's familiar with the tests used there, what would a reasonable surgeon do in a given set of circumstances? Well, of course, you can't expect a judge who is legally and not medically trained to answer that question. And for that very reason, there is a reference then across to a professional body of opinion of the relevant profession, whether that's medicine or architecture or engineering or whatever. And so it's an analogy to that, really. But I think the basic answer to that very good question is that we anticipate that expert witnesses in court will actually themselves be coded.
Thank you. And did I understand you correctly that I think you alluded to that it might well be possible for reasonable coders to disagree, so different experts taking a different view as to what it might have been meant by a particular code?
Yeah, exactly. And then, I mean, we were talking about this. I was talking about this with a Court of Appeal judge yesterday, and we had this exact discussion. I mean, I suppose in that sense, so there's two things to say about that. One is that, of course, judges have to do that all the time with all, excuse me, all sorts of experts. Or what you could do, I guess, is get the court to appoint a coder and maybe split the difference. I mean, that does definitely need to be worked out, but we feel very strongly that that is for the court to work out. I'm not quite sure that not quite sure what you could do in statute to ameliorate that situation. And as I said, I think it is analogous to what already happens in any sort of expert situation.
Thank you. Then I think our next question there was in connection with digital assets. So John is asking there, would this be akin to intellectual property, such as ideas, trade secrets, patents, that is intangibles?
No, so it wouldn't in this. Well, it could potentially be with NFTs, but the point that really needs distinguishing with digital assets and intellectual property is that what we really want to be conscious of is dividing up the use value from the exchange value. So, and what we're really concerned with is the use value, and that's what often gets overlooked with intangible goods. So obviously, if I go into a shop and I buy a novel, so let's say I go into a shop and I buy a novel, obviously what I'm interested in buying that novel is I want to have a book that I can take home. This is a bit of an ironic example, isn't it, when I'm talking about digitized assets, but somebody might have it on their Kindle. I still like reading books, right? So but I want this book. I want to be able to take it on holiday or sit on the train or whatever and read this book and enjoy the story and have this book. And of course, the other point is that this book might also be a first edition of Great Expectations. So let's say it's a first edition of Great Expectations. So it's one of my favorite authors, one of my favorite stories. It's also worth a lot of money because it's first edition. There is no expectation on my part that I take the intellectual property in that. I'm not, holding myself out as being Boz himself. I am not going to sell that on as my own intellectual work. That is not what I'm doing. But I care very much about the use value of that book. And I want my property rights in the copy of that book to be protected. I don't care about the intellectual property, don't want it, haven't got it, separate issue. That's a different part of the law, but I do care about my book. And I think that is the point that gets often overlooked with electronic things, because they can so easily be copied. I think we sometimes lose sight of the fact that they can be easily copied in some circumstances doesn't mean they always will be. And even perhaps if they can, there is still a value to be had in protecting one's own copy. And in the example I've just given you, if we think about NFTs, right, the Bleeple sale, which was what, 69.3 million. So I've got this intangible thing. It's worth a hell of a lot of money. It doesn't give me any intellectual property rights, but as a thing, as an analogy with a first edition, it's massively valuable in use value, not IP value, because I don't want to exchange it. I don't want to sell it as if I painted it or I made it, created it, minted it. There we are. But nonetheless, it is something that needs to be protected. So it's a really good question, because I think it is absolutely essential that we differentiate between those personal property rights and intellectual property rights, which are absolutely distinct.
Brilliant. Thanks very much. I think that's a very exhaustive answer to John's question there. So questions keep coming in, Sarah. So I'm not sure whether you're in the position to answer the next one, given that you said the private international law conflict of laws project is still forthcoming, but I'll voice the question anyway. How do you determine the law applicable to a smart digital contract?
Yeah, well, yeah.
Mm-hmm. Yeah. Okay.
Ask me in a year. I mean, the point, you see, at the moment, it's a perfect storm, right? So we've got Brexit. We have private international law. I'm not a private international lawyer. I will say that at the outset. I'm a personal property lawyer, but I've spoken to a lot of private international lawyers, and the general consensus is that at the moment it's pretty much in free fall. You know, these rules are in flux. And so what our private, so I can't give you the answer, I'm afraid, but what I can say, well, I can't give you a definitive answer. And it depends, of course, to some extent, what the dispute is, because it depends whether the dispute is ultimately classified as contractual or proprietary anyway. But that, I mean, that's the whole point of why we want to do this project, because at the moment there just isn't any certainty. This is what my private international law colleagues tell me. There isn't any certainty. There needs to be certainty. Parties deserve there to be certainty. So that's what we're looking to do. And I think to some extent it will be about choosing the most relevant law, because of course that's the most important thing for parties. Like what do we know about in advance? And with any sort of global transaction, with a smart contract or with digitized assets, I'm not even sure it's so relevant anymore to worry about, say, the domicile of the contracting parties, which historically we did, or the situs of the property, which historically we did. Because when you've got these agreements which happen entirely, say, on chain, does it, you know, how relevant is that jurisdictional focus? So I know that wasn't a very helpful answer, but it's the best I can do at the moment.
No, I think it's very helpful, Sarah. And Martina, I think, asked this question. So Martina, you see, the next project of the Law Commission will explore all those challenges. The next question is from Monica, saying, is the data generated from the smart devices consumers purchased also regarded as digital assets and are taken as the physical property of the consumers? Thank you.
Yeah, not necessarily. So as I said, and I know I didn't spend very long on the digital assets project, so apologies for sort of that being a whistle-stop tour. And it's a very good question, because it's really important for the purposes of that project that we're clear about where our definitions and therefore their implications begin and end. So as I said, what we're really trying to do is to pick out from the whole range of intangibles that we now currently have, pick out those ones which have the relevant characteristics which we think are analogous to conventional assets, which are transfer. Oh, so the important things are, I didn't even finish them. So one is the independent existence. This will answer your question. So one is the independent existence which I've already talked about, and data probably ticks that box, right? So the data will be there, whether I lay claim to it, whether you lay claim to it, whether there's a legal system that recognises it. So that ticks that box. The other two are, is it something that is amenable to exclusive control, exclusive possession, exclusivity? Can you keep others from it? And then the final characteristic is it fully divestible on transfer? Because then, of course, you avoid the double spend problem that you would otherwise have. And all of these things. So again, to use my analogy of a debt, we're not saying that intangibles like debts should become should be treated in this way. And I think the sort of metadata that you're talking about might tick those boxes. I think that would be factually context. But that's fine, and we want that. Again, we want that to be a virtue of what we're trying to do, because we have taken the view. I told you we'd worked alongside some other bodies, and some other bodies, I won't name them for now, but have decided to do similar things, but by setting out a sort of exclusive list of those assets to which their changes will apply, therefore meaning that the others, that they won't apply to the others. We don't want to do it like that. What we propose to do is to set out just those characteristics and say, if and when, we don't want to really go down the road of saying the following categories of thing will always be X and the others will always be Y. What we want to say is, if and when a given thing exhibits these three characteristics, it can be treated as property. It can go in our third category, and it can generate certain proprietary rights, and these will be the implications of those proprietary rights. So we'd rather do it like that. So I think in some contexts, the data that you refer to could tick those boxes, but it might not always.
Brilliant. Thank you. Now, next question from Robert, saying, to what extent are you factoring the dichotomy of client-server into the digital assets project? In other words, are you risking being distracted by clients and not paying enough attention to servers as the ultimate architecture supporting the DLT blockchain project?
I think my previous answer probably covers that one as well, because we don't discriminate between, we don't recognise that dichotomy for the purposes of our proposals. So as I've said, we're doing a sort of bottom-up approach, so the first principles. So rather than looking at it from above and sort of saying, well, these are the things that it's going to apply to and not, we've done what we've done based on principles. And we've done that for two main reasons. One is that we want to be as technology neutral and platform neutral as possible. That was really, really important to us, because, of course, at the moment, everybody's talking about distributed ledgers, and really distributed ledger technology is what enabled us to do this decoupling, because it facilitated electronic transactions and avoided double spend. So at the moment, everyone's talking about distributed ledger technology, but 10 years down the line, who knows? And who knows what the infrastructure is going to be? And who knows who the big players? We don't know any of this, and we don't really care. Because we want to be technology neutral, we want to be platform neutral, and we want to make sure that these reforms that we now make are going to be fit for purpose for the next 200-300 years. I mean, that might be a bit ambitious, but I certainly don't want to have to revisit them in 10 years' time when the infrastructure is completely different. So that's why we went down the route of doing the first.
Thank you very much. Now, the next question that I see, I think, Sarah, is a very challenging one. I'm not sure it's possible to answer this question in the abstract, but there we are. How would loss or damage be measured when cryptocurrency is involved, especially considering its volatility and its dual use as both a currency and as property? That's from Ali.
I mean, I think I don't think that would be very difficult. I mean, we all know it's volatile. Well, some of them are volatile. Actually, they're not all volatile, but of course they can be incredibly volatile. Certainly at the moment, there's a lot of damage being caused to some people somewhere because they're in free fall. But anyway, I think this is one of the interesting things that came out of the smart contract project. although the amounts are going to be in some cases quite scary, I actually don't think the principles of calculation need to be any different at all. Because this is what I meant with smart contracts. About when you think about it in the abstract, you think, oh, that's a bit, that doesn't feel like what we're used to doing, and it doesn't. But actually, you do need to apply the same tools because the same principles apply. If, for instance, you are protecting one of the parties' performance interests, well, you still protect their performance interest. And if everything else in that agreement and in that process works as it would with a conventional contract, there's absolutely no reason why you wouldn't use the same means of calculation as you would with a conventional contract. And of course, the best way of getting around that, of course, would be remoteness rules. And so as long as that loss comes within contractual remoteness rules, I personally don't see why that would pose any difficulties. I mean, the parties know that's the point, isn't it? And if there's nothing else that mitigates that, vitiates that, why not? I mean, that's freedom of contract, isn't it?
Mm-hmm. No, my sense is that, having worked with damages for some time, is that the traditional conventional principles of damage should be capable of handling this, but it's the precise way of calculating them that will have to be determined. But I very much agree with that sense. Thank you. Now, the next question, Sarah, is from our colleague here, Lirong, enjoying the talk and asking this. Can I ask a question in relation to digital money, especially central bank digital currency, or CBDC, please? CBDC allows residents to have a direct claim on central bank's balance sheet, which could potentially overhaul the entire banking system. It also poses challenges. Sorry, I'm just check the text just jumped. It also poses challenges to the law of possession and transfer of such assets, that is money. Is this something on the Law Commission's agenda before the potential rollout of CBDC over the next decade?
So CBDC, of course, I think is, as you obviously do, on the horizon. Quite a few people say to me, and still say to me, that they think cryptocurrencies and virtual currencies and digital currencies are going to disappear. I don't think they are, needless to say. But there's two aspects to that, because of course, once it becomes a central bank digitized currency, Laurent, as I know you well know, then there's a question of regulation. And what we need to do, I mean, the short answer is yes. The private law implications of digital currencies, whatever their basis, whether that's fiat or not, are the concern of the Digital Assets Project that I've talked about today. But of course, that needs to cover the full range from Bitcoin to CBDC. And what we don't do at the Law Commission, and what we do have to stay away from, which is why I'm being quite careful, is regulation. And a lot of the questions for a CBDC will be dealt with through regulation rather than the private law implications. But of course, all that said, we do need to set out what the private law status of these things is. Maybe you don't need to, but it's going to be a lot easier to regulate and a lot clearer to regulate once the private law implications are settled. So the short answer is yes, in part, because we will include the sort of in principle idea about possession. And if those currencies, now of course we all know that there is, I've talked about shows in possession, I've talked about shows in action, and we all know that money has its whole separate, money as currency certainly has its whole separate thing. We are going to talk about it, and we're going to talk about it in principle as digital currencies in general. But the CBDC aspect specifically is or are going to be things that are already being considered, obviously, by the Financial Market Law Committee, and will be essentially a regulation question, I think.
Mm-hmm. Thank you. Thanks very much. Now, these are the questions that we've had in the chat box so far. So we still have a bit of time. So please feel free to ask questions, whether in the chat box or by just putting the question directly to Sarah by turning your cameras on, and if you want to do so, then please introduce yourself first. Here's another question in the chat box. If the practice turns out to be that even DLT-based digital assets are to a great extent accessed and owned through interface providers, such as wallet providers, wouldn't that mean that they resemble choices in action? How a different approach may be justified in alignment with the technology neutrality principle? And that's a question from Ilias.
So do you mean they're intermediated? Is that what you mean by, because, are you able to tell me, is that what you mean, if their interest is intermediated so that holders have a more...
I can't clarify that.
Yes.
Ilias,
Okay.
if you could clarify this. Yes, he's saying yes.
Yeah. Okay, great. Thank you. I mean, I think the point there is, again, that's something that, as we all know, already happens. So we have okay. It's a really interesting question, and it's definitely something we are thinking about, and it's part of that project. I think it's probably not, again, like a couple of other things I've already mentioned this evening, it's not as much of an issue as it first seems. And it seems when you first think about it, how on earth are we going to deal with that? But I think with a lot of these issues, if you bring it back to an analogy with what we already have and what we're already used to, of course, we already have a very complicated system of intermediated securities, some of which are based in tangible assets underneath and some of which aren't. Really interesting question, of course, because your intermediated interest is an equitable one in nearly all of those cases. Unless you are, so you have a register system, clearly, as I'm sure you're aware. And if you are not named on the register as a person with legal title and your interest is intermediated, then you have an equitable title, so you have a right and a right. And then there's sub-versions of that all the way down. And that works fantastically well for a lot of investors, at least whilst everything's on foot, of course. Less so, perhaps, given the no look-through principle when things are not. But the point is, I think, with the Law Commission project, of course, what we do is we look, because we have looked at intermediated securities in the conventional sense already and quite recently. What we do is we look at, within our specific project, what the issues are that are specific to that. So the question being, is the intermediation of interests is in intangible assets? Or I'll say digital assets, because I'm not totally convinced that digital assets should be called intangible. But anyway, digitized assets. Is the existence of intermediated interests in digitized assets, does that give rise to any problems greater, above and beyond those that arise in relation to the same intermediated interests, but in different types of underlying assets? And I think the answer is no, it doesn't. So that actually, the recommendations that we made in our intermediated securities, I probably shouldn't call them recommendations. We did a scoping paper which highlighted those things that needed further work, and we did that the year before last. And I think the conclusions of that paper apply equally here as they do to intangible assets, because once you get to that intermediated level and you're talking about these equitable interests that are rights in rights, I'm not sure, although I'm, as ever, open to being corrected or certainly open to hearing a different point of view, I'm not sure that the status and the physical appearance of the underlying asset has any implications or different implications, certainly, for the intermediation of those interests. So that would be my answer. But as I said, I'm happy to hear if you think differently. Which goes for all my answers, by the way.
Thank you. Now, for a change, I think we have a question there from our colleague, Mateja Durovic. Mateja, please. Yes.
Yeah, thank you very much, and thank you. It's a pity you cannot be in person here at Kingsland. It's great to see you again, Sarah, and many thanks for a wonderful presentation, and Joachim, many thanks for sharing. So I would just like to have a brief question in relation to, because also the UK Law Commission dealt with the question on how consumer protection rules fit in the kind of the development of the and application of the smart contracts in practice. So my question to you would be now, as kind of UK is not anymore bound to follow European consumer law, and when we are talking now about some other kind of development and principles in the area of consumer protection, do you think, can you kind of think anything specific that could be kind of improved when it comes to protection of consumers in the area of smart contract? Because I mean, all the rules on unfair contract terms, unfair commercial practices, pre-contractual duty of information, they all come from the EU law, but now we kind of can change them here. So can you think of anything? Thank you very much.
Yeah, that's a really good question. Thank you very much. It's nice to see you again, albeit in 2D. So I didn't talk about it this afternoon. It was one of the things that I had to leave out for the purposes of time, but we did consider the implications or potential implications of consumer protection with smart contracts. And of course, one of the natural questions that arises there is about transparency of terms. I mean, that's the obvious one maybe to focus on, where you have consumers who are engaging in a smart contract and maybe not code literate. But actually, again, I feel a bit like a broken record. Although we thought initially that was going to be a problem created specifically by smart contracts, we realized that actually it probably isn't any worse than conventional contracts, because the same requirements will apply to, say, traders. So if I talk about the CRA 2015, the same requirements for transparency, etc., will apply to traders. So they still have the same incentive to, you know, acknowledge that their consumers are maybe not going to be code literate and provide a clear translation. But so this is the other interesting point. So that's as far as smart contract goes and the particular requirements of smart contract. What I think does make a difference and will make a difference, and this is one of the projects that the Law Commission wants to do next, for the very good reason I suspect that you've asked your question, excuse me, is, as we all know, all this consumer protection is all very well in your trader consumer context, and that's going to protect, we think, consumers as against traders in as far as it does with conventional contracts. But of course, as we all also know, increasingly these sales are peer-to-peer, and a massive proportion of them now occur on peer-to-peer platforms, which would not be captured by this current consumer protection law, certainly not in English and Welsh terms. So we think actually that the focus should not be on smart contracts as compared to conventional contracts. We think the focus should be on increasing consumer protection, because again, it's obvious to most lawyers that just because you don't fall within the definition of, say, trader for the purposes of, consumer for the purposes of the CRA, doesn't mean that you're in the same bargaining position as the person that you are buying from or transacting with. So I think it's a very good question, and the short answer should have been that's something that the Law Commission very much wants to look at as part of its 14th programme, which is its next programme of law reform, which focuses more on the platform rather than the nature of the contract.
Thanks very much. If I could just use my position here as I ask just two quick general questions that probably relate more to the nature of the decision making within the Law Commission, because ultimately you say that you're in the listening mode, of course, but ultimately you do take a position and make some recommendations. So my question is really twofold. First, I mean, from what I've seen during the consultation process on electronic documentation, unsurprisingly, there are very different views on these matters in terms of how the law should and can respond to electronic documents, for example. So hearing all these different views, ultimately, how do you make a decision? How do you take a stance from within the Law Commission? What ultimately are the drivers in terms of the conclusions that you reach and recommendations that you make? And a sort of related question concerns the consultation with the relevant stakeholders. So, of course, you consult the industry and the different parties within certain sectors in terms of what their views are, and presumably what legal reform they would like to see. But in certain areas, for example, international trade, a wide range of parties participate. Many businesses would buy and sell. There'll be numerous carriers and so on. So how do you identify, who the relevant stakeholders would be, whom to consult, in other words, if that makes sense?
Yes, it does. They're some of the hardest questions I've been asked to Conge, so thank you. Of course, I should say thank you to you, because you have been fantastically helpful, not least on the electronic trade document. So one of the stakeholders that we spoke to was Conge, who was hugely helpful. What do we do? We do see a lot of differing views, and then there are a number of ways of which we deal with that. So whilst we're talking to stakeholders, we're also doing our own research in-house. So we have a team dedicated to each project. And what we try and do at the end is assimilate what we have found out in terms of sort of objective legal research with what stakeholders have told us. There's a little bit of weighing it up in terms of numbers. So if we've got, we might have two very polarized views, but there might be more people who agree with one than the other. Sometimes it is really tricky and it's really finely balanced, and it seems to be a sort of 50-50, in which case it does, I suppose, fall to me, as I have the buck gets passed to me, and I have to make a very finely balanced decision, which we then usually consult on as well, and tend to either elicit support or otherwise. There is also something else about the Law Commission, so I'm glad you asked me this. When in my job now, as compared to my job when I worked in academia, there is obviously another dimension to it, which is that I cannot just go for the argument that I think is most appealing to me, or that I think is most conceptually elegant, or just feels a bit coherent, more coherent than others, and would make writing a textbook easy, that sort of thing. You can't do that, because of course what we're also very keen on doing is ensuring that our reforms actually get implemented. So sometimes, quite frankly, it is a question of deciding what is going to be the most palatable reform, because we think that in many cases a reform that's better than the status quo is better than no reform at all, and that if we did what, say, certain stakeholders might want us to do, we know the government's just going to say, no way, I'm not touching it, and then everybody loses. So it's a really interesting question, because it's a big melting pot of things. So it's partly academic, it's partly conceptual, it's partly populist, I should say, in terms of stakeholder numbers. But there is also an element of strategy, because, as I said, it is better, I think, to have a reform that's better than we've got now, even if it's not what everybody would think is perfect. And in terms of identifying stakeholders, that can be quite difficult, although it's slightly easier now. I mean, I dread to think how hard it was pre-social media. I mean, I find it really easy because it's the sort of LinkedIn effect. I don't necessarily mean using that platform, but if you speak to one person or one organization and they're really helpful, and they say you should speak to X, Y, and Z, and there is a snowball effect. We also do social media campaigns, so that we try and make it as obvious as possible. And quite a few people come and ask and speak, want to speak to us, and they will introduce themselves to us. So there's a mixture of things, really. But a lot of it is, particularly in this area, I was fortunate enough to know a lot of people who work in the space. So it was people talking to people. But yeah, the internet is fantastically useful, and we just try and go as viral as we can, really.
Thank you very much. I know we're running out of time, but there are two more questions in the chat box. Do you have time to answer those?
Yeah.
So here's a question from Param saying, thinking about the impact of tort negligence, if digital assets are treated as possessable property, could they act as actionable damages for a negligence claim? For example, if your data controller corrupts your code in a non-criminal way, could you bring a claim against them in the tort of negligence? Could this create a new tort?
Yes and no. Yes, I think you definitely could, once they come within the boundaries of what can be the subject matter of a property right, the object of a property right. then absolutely there's no reason why they couldn't be subject to a claim in negligent interference, in trespass, in conversion, reversion re-injury, you know, the full suite. Yes, no, I don't think we need a new tort. I think it would just be, you know, negligence in the same way. It would be property damage in the same way as it currently is within the tort of negligence. And would also, I mean, I should say, these are my thoughts. We don't have final answers in terms of the Law Commission position on this yet, but in terms of a hypothetical, if they become property and are treated analogously to tangible property, I don't think we would need a new tort, just be property damage under negligence as far as I could see.
Thank you. And the next question is saying, my question is, what are the level of preparations that an organization practicing in conventional contracts need to do, in addition to the legal due diligence, in the event that it intends to migrate into the realm of smart contracts? Additionally, is there a certain type of contracts that could only be included within the spectrum of smart contracts?
So I mean, this is the thing about all of this emerging technology. I think ultimately and in the medium term, it's going to lead to quite a few cost savings. I mean, they're, you know, obvious without the uses of paper and, you know, there's less friction. There will ultimately be fewer transaction fees, for instance, so on and so forth. But of course, there will be an initial outlay because in a lot of cases, certainly SMEs are going to have to invest in particular technology if they want to be able to use smart contracts and transact in digital assets, because they'll need to make sure that their assets tick our boxes if our reforms go through. So there will be an outlay. And I think, as I said, we're very, very conscious that we are technology and platform neutral. So there certainly wouldn't be a recommendation of a particular proprietary organisation. But I think it will be important to adopt a kind of reputable platform to make sure that what you are doing will be enforceable and will be within the parameters of our recommendations, should they go through. And I've forgotten the second part of the question. Sorry, what was the second part? Oh, yeah, which types of contract?
Yeah.
No, so so the short answer is no, and the reason for that is because the thing I was saying at the start about how broad the definition of smart contracts are. So basically, it can be a contract which is apparently sort of totally conventional. It's all written completely normally in, say, a Word document. And there could be just one little part of it that's automated, even just a tiny part of it that maybe uses an oracle to get a price on a given day. And that's a smart contract for our purposes. And, you know, that's fine. As I said, eventually we decided, although it worried us to begin with, we decided that actually was a virtue, because what's really important here is that the law covers all eventualities. So we're not going to exclude, we're certainly not in the business of excluding certain smart contracts because they're not smart enough. So between the sort of tapestry of conventional contract law and smart contract law should cover the whole ground, really. So the short answer is no.
Excellent. Thank you very much. Now, I think we've reached our limit. I don't think there are any more questions there in the chat box. I hope I haven't missed anything. Just perhaps a final call for any questions if somebody wants to slot a quick last-minute question. Just to give a few more moments.
Pressure's on.
But I think there have been many questions, and I think it's time to bring it to the end. Sarah, thank you very much indeed for this wonderful presentation and such exhaustive and detailed answers to each of those excellent questions. Very much appreciated. It was truly fascinating. I found very stimulating and thoroughly enjoyed it. You can also see from the comments that our audience has also enjoyed it enormously, and very grateful to you for your wonderful presentation and all the insights. Very thought-provoking. I'm sure we'll continue discussing these things in the years to come. Clearly some fascinating projects ahead for you in the Law Commission, and very best of luck with those. So I certainly look forward to seeing the work of the Law Commission going forward. And I think you've made a great contribution to all that work. So thanks very much for taking the time. Thanks for being with us. And also big thanks to the audience for joining in and for all your wonderful comments and questions. So with that, I think all that remains is a virtual applause. That's my applause here. And I'm sure there's also virtual applause there in the audience. So thank you very much, everyone. And thanks, Sarah. Great to see you as always.
Yeah, it was a pleasure. Thank you very much, everybody.
Thank you.
Bye.
Bye-bye. Thanks very much. Bye now.